On Wednesday, October 8, 2025, the spotlight once again fell on Nnamdi Kanu, the immatricator of the indigenous people of Biafra, IPOB, as he was brought before the Federal High Courts in Abuja. The courtroom scene, though predictable in many regards, carried with it the weight of an ongoing struggle, not just of one man, but of a principle. That is the principle of the rule of law and the boundaries of state power in our country. The way things are constituted. When Kanu arrived, his presence was unassuming, yet resolute, confirmed by his special counsel, that is Barrister Aloy Ejimako. His entry into court was calm, with the usual legal entourage surrounding him. The court was presided over by Justice James Omotosho, and the stage was set for the usual legal contestations. Let us watch a bit of the proceedings, and I'll be right back.
We just emerged from the closure of proceedings in the case of Nnamdi Kanu for today. The story is not going to be too long, it's very short. The prosecution made a motion, an application to adjourn this matter because the Nigerian Medical Association did not file the report that the court mandated it to file on the last adjourned date. And that report, the kernel of that report is actually to advise the court whether Nnamdi Kanu is fit for trial, or continuation of trial, and whether he deserves to be transferred to a hospital, i.e. the National Hospital. So that report was not in, so for that reason the prosecution made a motion, an application to adjourn the matter to another date, and the judge granted the application and adjourned the matter to 16th October.
So on the issue of medical counsel, yesterday medical counsel sat on the issue that has to do with Professor Aj, and when I got the information, I went to that place because I've written a petition against the DSSS doctor, the one that never examined Nnamdi Kanu, and wrote the report. That was a couple of years ago, and nothing happened. Then I also wrote another one against the doctor that never examined Nnamdi Kanu, but had the audacity to depose 37-paragraph affidavit countering the report of Professor Aj. But surprisingly, they left my own petition and be treating another issue. I went there, confronted them with it, so they succeeded in intimidating me and harassing me with a petition against me at the FPDC. But that one is a different ballgame altogether. Now to the President, Mr. President, the President of the Federal Republic of Nigeria, please, as a matter of urgency, direct Attorney General to discontinue this funny charge. This charge is embarrassing Nigeria the more, and the more they keep on applying for adjournment. I know that they must have advised you, telling you that they don't have a case. I heard them saying. So in order to protect the integrity of Nigeria, please allow them to discontinue this particular charge, and so that Nnamdi Kanu will continue with his agitation. Address all those issues that gave rise to the agitation. Everything will calm down. Anything short of that, if Nnamdi Kanu is released, he's expected to continue with the agitation. That is the naked truth. There's no going back. And all those people that are dancing around you, praising you, they are deceiving you. They are making your government unpopular. We are the people that are helping your government, telling you the truth. Attorney General will not tell you the truth, of course. No, don't touch me. Attorney General will not tell you the truth, and then another person will not. We are the people that will tell you the truth. They don't have a case against Mazi Nnamdi Kanu. Of course, you know that had it been that Nnamdi Kanu is from the north or from the southwest, he will not be here today. They are doing him because he's from Igbo. Nobody should touch me. Allow me to express myself. It's my right. So Nnamdi Kanu is suffering this thing because he's an Igbo. He's from southeast. Those of you that are in the House of Assembly, Senate, bench warmers, we watch what is going on. At the appropriate time, we will tell you people that yes, the masses are watching you. Thanks and have a nice day.
Yes,
and
we are
saying
that if they like, the government of the day should apply for record of proceedings so that they will realize the frivolity of the charges and the evidence already before the court. There is no reason for this prosecution. All the decisions of the court ought to be reviewed so that they will know the frivolity of what is happening before the court. Thank you.
Well, thank you very much, all lovers of freedom. Please take a listening to what I'm saying. Nigeria is a country we all love and we want to love. But we cannot love this country unless this country begins to do equity, begins to do justice, and begins to do fair play and fairness to every citizen of the country. Chief Chukwuemeka Odumegwu Ojukwu went into the Biafra Civil War because of injustice. Now, Ralph Wazulike went into agitation for Biafra because of injustice. Today, Nnamdi Kanu is fighting the same injustice. And let me tell us, even if Nnamdi Kanu today stops today, there will be 10,000 other Nnamdi Kanu out there willing to take up the fight. And I must tell us that even my own children know that we are first of all Biafrans before we are Nigerians. Nobody can take that from us. We are first of all Biafrans before we are Nigerian. Just like you are Odudua before you are, or Yoruba before you are Nigerian. Just like you are Ariwa before you are Nigerian. Nobody can take our identity away from us. So let Nigeria know this and know this.
They should not manipulate the reports, because already we have already had the reports before they came, and when they examined Mazi Nnamdi Kanu, they even detected more inmates that even the previous doctor could not even see. So that when they are writing their report, they should not manipulate it, because we already had the report before even the actual report they are going to bring.
If you have followed up to this point, please share, comment, and subscribe for more information on my channel. As the proceedings unfolded, the court requested that the Nigerian Medical Association, NMA, furnish a report on Kanu's health to assess or ascertain whether he remains fit to stand trial. That request in turn led to another adjournment. The case was deferred to October 16, 2025. How long is it going to last? In other words, once again, little substantive progress was made on this case, not for lack of legal maneuvering, but because the machinery of judicial delay continues to grind as far as this matter is concerned. The side of Kanu in court today must be read in the context of an ongoing and relentless detention, one that persists despite repeated judicial decisions, injunctions and appeals that call for his release, or at least free access to a fair trial. Over the years, multiple courts have found in favor of Kanu's right. Yet those decisions have often been ignored, stayed out of decision, or subverted in practice. The Nigerian government has appealed favorable decisions and in some instances deferred implementation, leading to a protracted stallment. Similarly, the UN Human Rights Council Working Group on Arbitrary Detention has expressed concern and regarded Kanu's detention as arbitrary, particularly in light of his extrajudicial rendition from Kenya in 2021. Therefore, the courtroom physical trappings, that is, the gravel, the bench, and other formalities, contrast painfully with the reality that Kanu is, in many regards, already tried by delay, not by justice. That is what he has been faced. The fact that the court should demand a medical report is not on its face proper or improper. Truly, medical report to stand trial is a legitimate concern. Yet, in the history of Kanu's case, it's quite different. Requests for health assessment have often accompanied delays. procedural opacity, and raises questions over transparency. The timing and repetition of such requests risk being viewed as tools of stalling rather than sincere effort to protect a defendant's right. That is exactly what is seems now in his own case. Civil society, diaspora groups, human rights organizations, and concerned individuals have repeatedly sounded alarms about Kanu's indefinite incarceration. In June 2025, for instance, the American Veterans of Igbo Descent warns that Kanu's detention continued even after court orders for his release, framing it as part of a broader effort to stifle dissent. Meanwhile, IPOB has accused the federal government of interference in his trial, suggesting that the judiciary is being prosecuted and intimidated. Yet, the responses from state institutions remain perfunctory. The repeated adjournment, the slow pace of compliance with court orders, and the lack of clear timelines for release suggests a toleration, even as an institutionalization of indefinite detention by legal fiat. And what are the implications for rule of law and democratic legacy or legitimacy to our society in all of this? When a legal system allows or enables the persistence of detention in defiance of judicial mandate, it chips away its own legitimacy. The image of Kanu, handcuffed or escorted, facing a judge who must request a health report before continuing, calls to mind a system where power overrides procedure and where justice is conditional on executive tolerance. Moreover, in a plural society like Nigeria, with persistent tensions across ethnic, religious, and regional lines, the appearance that dissenters can be sidelined through legal attrition is deeply eroded. The grievance that foments protests, separatist agitation, or civil disobedience finds fertile ground when avenues for redress appear blocked in a situation like this. To chart the way forward, if the judiciary truly upholds its rulings, then Kanu's release, or at least the grants of bail with appropriate guarantees, cannot be endlessly postponed. The principle of presumption of innocence demands it. That is what we should uphold. If fitness to stand trial is in question, the process must be transparent, independent, and governed by clear medical protocols, not an excuse for delay. It has to be stated clearly. Also, courts that issue orders for release or procedural compliance must see those orders respected. If the executive branch or security agencies resist, that resistance must be challenged and remedied through constitutional mechanisms. It is possible. Nigeria must allow independent observers, right organizations, legal monitors, and press to scrutinize the process. Admission of international oversight, or at least credible domestic monitoring, could help restore confidence in the system. That is what is going to play out. Beyond Kano's case, Nigeria must confront how it treats political detainees. The overuse of security legislation and the intersection of counterterrorism law with civil liberties. Prolonged detention without resolution must not become a standard tool of governance in our country. And my final take on this is that Nnamdi Kanu's trip to court today appears routine on the surface, with a defendant, lawyers, judge, procedural motions. But the deeper story is one of a legal system stretched to accommodate indefinite power rather than constrain it. His continued detention, even as courts demand his release or to evaluate his fitness, is a stain on Nigeria's claim to constitutional order. If the Nigerian state purports to be democratic, then it must confront and correct the institutional malice that allows such miscarriages of justice. Otherwise, the image of a man chained to procedure becomes emblematic of the nation itself, bound by the very laws it claims to respect, yet unable or unwilling to honor them. Thank you.